Morning.
May please, Lordships. I may be allowed to make a mention for hearing item 41. I have the consent of the learned public prosecutor as well. If the matter can kindly be listed after 3 weeks.
Item 41. Item 41, okay. It's the matter of the 3 weeks on the prayer of the learned counsel for the petitioner. Learned counsel, our learned government advocate is present.
Much obliged.
Lordship, I beg to mention item number 53 from the supplementary list. This may be possible, listed on Monday.
Okay. 53, list this matter on Monday on the prayer of the learned CGC.
Obliged. May it please your lordship, I beg to mention item number 42, lordship. On Tuesday, lordship, the government council had brought to the notice of this honorable court writ appeal 2, 3, and 4 of 2025, which is pending before the division bench. So I've gone through it, and the facts are similar, lordship, and the issue involved is similar. So if it can be listed after the disposal of that
Writ appeal,
division.
huh?
Yes, lordship.
this is item 42, okay? It has been submitted by the learned government advocate that the issue involved is under challenge. The issue involved in this rate petition is under challenge in writ appeal
Two,
Two,
3, and 4 of
2, 3, and 4 of 2024.
2025.
2025. Accordingly, list this matter after disposal of the aforementioned writ appeals.
Obliged, Lordship.
Please, Your Lordship, I beg to mention hearing item 47 and 48. If this matter can be listed on 2nd of June.
List the matter on 2nd June for hearing on the prayer of the learned counsel for the petition.
Petitioners.
May I please, Your Lordship? I'm appearing for respondent number 10 and 9, Lordship.
Learned counsel appearing for respondent number
10 in item number 47 and
10.
number 9 in item number 48, Lordship.
9 has no objections.
Lordship. Obliged, Lordship.
May I please, Your Lordship, may I be pleased to mention hearing item number 46 on behalf of AIME, Your Lordship, if this matter can come up after 2 weeks.
No objection. Prayer is made by learned government advocate Livika, praying on behalf of Miss AIME, counsel for the respondents, government respondents, to list the matter after
2 weeks.
2
Your Lordship.
weeks. List after 2 weeks.
Your Lordship, I also beg to mention admission item number 15 to 32, Your Lordship. Your Lordship, here I am supposed to file an affidavit in opposition in item number 15. The rest I have already filed. I have to file in 15. However, Your Lordship, due to my medical reasons, I could not able to prepare the affidavit. It's incomplete, Your Lordship. It's under preparation. So, Your Lordship, if another 3 weeks may be granted, so that within that time I will file my affidavit, Your Lordship.
Learned government counsel, Ms. Livika has prayed for 3 weeks' time to file the counter affidavit in WPC 7 of 2025. Stop prayers allowed. List the matter after 3 weeks.
Yes, it's
Learned
all
counsel.
analogous, Your Lordship.
Yes,
It will be.
15, this will be 15 to 32. 15 to 32, isn't it? Yes. List the matter after 3 weeks. Stop learning counsel for the petitioner has no objections.
Your Lordship, I also beg to mention item number 10 and 11. Your Lordship, here actually it's an admitted liability, Your Lordship. However, the government is seeking for some time again, Your Lordship.
Mm.
So if this Lordship can be gracious to grant another 3 weeks. Your Lordship.
Give us the last chance, Lordship.
Okay, if in case 3 weeks, after 3 weeks, you can't pay, then we'll dispose it of, okay? Item 10 and 11. Council, learned government advocate Livika prays for another 3 weeks' time. With the necessary payment.
Yeah,
Make
Your Lordship,
the-
yeah.
The
Not payment, Your
outstanding,
Lordship, to know the status of the
to
case of the
obtain the
petition.
status of the pending bills.
Yes,
Is it
Your Lordship.
pending bills to be paid to the petitioner? Praise allowed, list the matter after 3 weeks. Learned counsel appearing for the petitioner prays that this may be the last chance, last opportunity. Stop. It is made clear that on the next day, if no instructions are received and the prayer is an admitted liability, this court will dispose of the application at the admission stage.
Pledge, Lordship.
May I please, Your Lordship? Lordship, I beg to mention hearing item 49, Lordship. Lordship may be gracious if this matter may come up after 2 weeks.
49. List the
49.
matter after 2 weeks.
2 weeks.
On the prayer of the learned counsel for the petitioner.
Much obliged.
May I please, Your Lordship, I beg to mention item number 4. The affidavit in reply still under preparation, so kindly grant us 2 weeks' time to file the same.
Item 4,
Yes, Your Lordship.
you are appearing for CGSC
For the petitioner, Lordship.
for reply. You want
Yes.
to file a reply?
Yes.
Okay. Item 4, learned counsel appearing for the petitioner has prayed for
2 weeks.
2 weeks' time to file a reply to the counter affidavit of the respondents. Prayer is allowed, list the matter after 2 weeks.
Yes, Your Lordship.
Yes.
So I'd like to mention items 43 and 44. Lordship, if the matter can come up on 2nd of June, my senior is
43
out
and
of station.
44
43 and 44.
by the learned counsel for the
Respondent.
respondent to list the matter after 3 weeks.
No, Lordship, if can come up on 2nd of June.
To list the matter on 2nd June as his leading counsel, who, Mr. Sharma,
Inti Wabang.
Mr. Wapang is indisposed. Counsel for the petitioner has no objection, list the matter on 2nd is okay,
Lordship.
2nd June.
Lordship, similar prayer for items 7 and 8.
Yes,
Similar prayer.
same order in item 7 and 8 on 2nd June. Yes. Here also your respondent
Lordship.
on the prayer of the respondent.
May I please, my lady?
Yes.
My lady, item number 7, it is service report is awaited upon respondent number 1 and 2. This honorable court, by order dated 24/3/2025,
Mm.
had issued a notice upon respondent number 2 and 3. However, despite service, the notice is awaited. Service report is awaited.
Respondent 2 and 3.
Yes.
See that. You are for respondent 1.
Yes, Lordship.
Item 7 and 8. As per office note dated 4/4/2025, service of notice on respondent 2 and 3 is still awaited. You take steps again.
Okay, ma'am.
The petitioner is directed to take steps for fresh service of notice on the respondent number 2 and 3. And list the matter after you asked for 3 weeks, no?
Lordship, if it can come up on 2nd of June.
Okay, list the matter on 2nd June.
My lady, can it be on 30th of this month? I have some difficulties on 2nd. If it can be accommodated.
3rd then, 3rd June.
Okay.
3rd June.
Lordship.
Obliged.
For motion, item numbers 1 and 2.
May I please it, your lordship? My learned friend is here, lordship. I am here, lordship.
Okay.
So, lordship, this is a transfer petition, lordship, under section 447 of BNSS Act, lordship. The case is that, lordship, bearing Difupara PS case number 41/2024 under section 316 and 318 of BNS Act, presently pending under Difupara Police Station, lordship, in a investigation is stage, lordship, moreover, lordship, under the Chief Judicial Magistrate Court of the Dimapur, lordship, and paid for and sought for direction to transfer the same, lordship, to the any other district in the state of Assam, lordship. That is the FIR, lordship, page number 17, Annexa A, lordship. Annexa 1 kindly be pages, lordship. That is the FIR, lordship. This FIR, lordship, by informal, lordship, stated that, lordship, the one JCB has provided to the informal, lordship, and lordship, accordingly, he has received 8 lakh rupees, and subsequent stage, your lordship has seized the said vehicle as per the executive magistrate of Golaghat, and same has been returned back by the police personnel of Golaghat, lordship. That is the allegation. So my case is that, your lordship, I have no objection regarding the same. Definitely, I will cooperate with the investigation authority. It is my duty bound. Accordingly, lordship, in previous stage, lordship, I have filed bail application being number 10/15 25 Lordship, and Honorable Court has directed to me to appear before the IO. But Lordship, the problem is arises there, Your Lordship, that the NSCN has issued previous stage letter to me, Lordship, to provide them, Lordship, out of the profit, Lordship, 5% to them. Only because of that, not only this, the one letter, there are the number of letter NSCN, Lordship, extremist has issued to me as annexer. Annexer 3, page number 24, kindly be perused. That is the notification, Lordship. So in the format government, Lordship, the NSCN has issued letter to me. Kindly be perused, Lordship. May I please to read it?
Yes,
So,
yes.
Government of the People Republic of Nagaland, Office of the Longfu, General Headquarters Naga Army, dated 27/2/2024. That is the notification. Contractor office search of the oil drilling works being carried out by ONGC of Sungajan Amguri in Golaghat district of Assam is hereby informed to obtain authorization from this office wherein which we will not allow to work to continue. It should be noted that no development drilling can be done without the consent of the stakeholders. Therefore, contact the intermediary agent for further instruction regarding this matter immediately. Apart from this letter, another letter has sent to me. That is the Annexer 3, page number 25. Kindly be perused. This is the summary. Summary where it stated the Naga Army, Lordship. So may I please to read it?
Okay.
So Nagaland site on the prolific Assam Akram basis within the Naga Sopwan oil belt, which is considered the main source for the feeding at the oil and natural gas field in the Assam and Arunachal Pradesh, Nagaland, has an estimated potential of 600 million tonnage of crude of reserve. Apart from this, so far, the exploration works in Naga area have been put on hold since the year 90s, the reason being seek political solution first. However, present CM Nagaland and the Assam met in April last year and had reportedly agreed to principle for oil operation along with the disputed area belt on the equal revenue sharing. While formal MOU is yet to be signed in this regard, it is to be noted drilling works have already been go on in the Assam side. So the dispute arises only that, Lordship. The Naga Army has issued the frequently letter to me, even also if threatening to me.
Okay. Who accept notice? Yes. Get instructions regarding the transfer and also whether security can be provided.
Yes,
to
Your
the-
Lordship, I
to
think
the
that will
petitioner.
be the correct, yeah, correct procedure, Your Lordship.
This is an application filed under section 447 of the BNSS, praying for transfer of the Dipupar PS case number 41/2024 under section 316 clause 2/318 clause 4 of the BNS 2023 in the court of CJM Dimapur to any other police station / court in the state of Assam. Stop. The petitioner has submitted that an FIR has been lodged against him at the Dipupar PS. However, he is unable to appear before the investigating authorities due to the fact that he has been given several notices by some underground organizations, and due to the security threat, he is unable to reach the police station, the Dipupar police station. Stop. Issue notice returnable within 3 weeks. Learned PP Livika has accepted notice on behalf of the state respondents. Hence, no formal notice is called for at this stage. The petitioner shall supply extra copy of the petition to the learned PP. List after 3 weeks. No?
So, Lordship, interim protection may be given, Lordship, only because of that, Lordship, the previous stage I am unable to appear before the court, despite repeated instruction of this honorable court also, Lordship. So, in this regard, Lordship, even, Lordship, I have also tried to appear before the IO, Lordship, and coming to the from Assam to Nagaland, Lordship, but some unknown person has followed me, Lordship. In this regard, Lordship, I intimated immediately to the officer in charge of the Dipupara police station, Lordship. Accordingly, Lordship, GD entry has been made out 5/25, Lordship. So, Lordship, my learned friend has submitted this application before your Lordship. So, kindly paying this my submission, Lordship.
Your Lordship,
letter, Lordship.
I may make some humble
That is
submission.
Sunadar PS, not
What happened is
Dipupara,
that Your
Lordship.
Lordship, on 2 occasions, as Your Lordship already knows, opportunity was given, he did not appear. The thing is that the least the IO expected is that at least the counsel of the petitioner should at least call that this is the position. However, that is also not done, Your Lordship.
It is absolutely
Clearly, it's a
correct, Lordship.
clear
I have a duty
advantage,
bound to
taking
appear
advantage
before
of
the IO,
very
Lordship, but I
precious
have
time.
tried to going on, Lordship.
That is
But
not done.
Lordship, when
So,
I
the
am
present
crossing the
petition,
Yes,
transfer
Your
Assam
Lordship.
border area, Lordship, some unknown person has followed me, Lordship. I immediately
Can
went
you
back
please,
to the
can you please
Sungagan
listen to
PS.
the court once?
Your Lordship, my learned friend will submit, Lordship, this application,
Your
Lordship.
interim prayer is that to stay the further proceedings. Just that.
Yes, Lordship, that is right.
Returnable date. Okay. After that, the court will decide on the next day whether it is to be transferred or not. Then,
Your Lordship, then if it can be make 2 weeks. Your
2
Lordship,
weeks. Yes, returnable within 2 weeks. And till the next returnable date, the proceed investigation under the in case number 41, Tipupar case number 41/2024 is state. Yes.
From the supplementary
Fifty,
court.
Lordship.
For motion, item number 50.
May please Lordship.
Deletion.
My lord, this item number 50, 51, and 52, these three are analogous. And in all these three, I have filed one IAH for deletion of the respondent number 2, 3, and 4, as they are not necessary party in this present application.
The present IA has been filed by the petitioner, praying for deletion of the name of respondent number 2, 3, and 4 in the present bail application, as their names have been inadvertently impleted as respondents number 2, 3, and 4. Learned learned PP, TIPACOM is present. Stop prayer is allowed. The petitioner is allowed to delete the respondent 2, 3, and the names of respondent number 2, 3, and 4 from the application. Application stands disposed of. So,
My lord, coming to the main
yes,
petition,
yes.
coming back to the main petition, this matter was heard on 24/4/2025, and interim was allowed. And with the direction to do the petitioner to appear before the IO on 1st of May. Yes, 1st of May.
You have appeared.
Yes, and thereafter also the IO has my lord, this case was first registered as 0 FIR at Milore. Thereafter it was transferred to Kifri. Again, thereafter it was transferred back to State Crime Police Station and re-registered as State Crime Police Station case number 4 of 2025. My lord, I'm submitting a copy of that. why that happened is because the very place where the incident happened is in a place, territorial place of two different districts. One falls under PEC and the other falls under Kifri. So that is how it has been transferred as state crime police police station case. And CD has also been called for. So if
May I please, Lordship?
Yes.
My lord, as per the direction order given by the Honorable Court on 24/4/25, I've received this original CD, copy of the CD, my lord. And in the CD, it is recorded that petitioner has already appeared
Appeared.
as directed. Yes, my lord. Your Lordship, may kindly see the original CD, my lord.
Petitioner is Stromoli. This is arising of the same case, all three.
yes, madam. Yes, madam. The petitioner's name were named in the FIR. That is how they have filed this and this repeal application.
When did the petitioner appear? Which date? First.
First, your Lordship, may kindly see the last page. I've already flagged, my lord.
As per the direction, we appeared on 1st. Thereafter also, we were summoned on 6th. So we have appeared on that day also.
Yes, ma'am.
As long as they are cooperating with the investigation, I think. We can
Yes, my
go
lord.
on.
If they are going to cooperate the investigation process, as and when they are called for, then I have no objection, my lord.
This is in the main petition, okay, 11 of 2025. Heard Mr. Taka Kichu, learned counsel for the applicant, and Mr. Tipa Pong, learned PP for the state respondents. On 24/4/2025, this court had granted interim pre-arrest bail to the applicant on the condition that the applicant shall appear before the OC Police Station Pongro or the investigating officer of the case on 1/5/2025 without fail. Stop. Several other conditions were also imposed by this court. Stop. Today, the learned PP has produced the updated case diary, and the court has gone through the same. It is seen that the applicant had appeared before the investigating officer on 1/5/2025 and also on 6/5/2025, and his statements have been recorded. Stop. It is also seen that till date, the applicant has not violated any of the conditions laid down by this court in the order dated 24/4/2025. Upon going through the statements made by the applicant and also the facts and circumstances, this court is of the view that the interim pre-arrest bail granted on 24/4/2025 can be made absolute. Stop. Accordingly, the interim bail is made absolute on the same terms and conditions as laid down by this court on 24/4/2025. Stop. The petitioner/applicant shall continue to cooperate with the investigation and appear before the IO as and when summoned. With the above directions, the petition stands disposed.
Much obliged. May I please, Your Lordship?
Same order.
May I please, Your Lordship, will kindly return me the CD.
Yes,
This is the
yes.
original copy.
The CD is returned, original CD is returned to the learned PP.
Much obliged.
Same order in the other two items, but only the name of the petitioner will be different, okay?
For admission, item number 3.
Members, Lordship, Lordship, on behalf of Ed Angami, he's engaged before court number 1. So if this matter will come up after some time.
Your Lordship, this is for the appointment of an arbitrator. The only question that has been posed to both the parties by this honorable court is whether the proposed name that is retired Justice B.K. Sharma,
Is agreeable.
whether they are agreeable. Your Lordship, as far as his Lordship is concerned, he is known for his fairness. So they may also agree, we never know, but the instruction, waiting for the instruction is taking such a very long time. And it is not fair, especially for an arbitration petition to be lasting this long. That's the only issue.
Tomorrow? That is the question. So you just come whether it's agreeable or not. That's the only thing. After that, the court will appoint, lay down the terms and conditions. That's all.
Yes, Your Lordship.
Lordship, I will not be able tomorrow, on Monday.
No, whether the union is also agreeable. Both the union and the state
I have no
respondents.
instructions of what.
Lordship, as far as the union is concerned, the instruction was so to be taken by the order dated 17 March 2025. So I do not blame my learned senior colleagues, but it's unfair that the union is not responding at all. It's like taking this honorable court for a ride. This proceeding has been dragging on mostly because of the union respondents, Your Lordship.
It's just one line, whether you agree or not to
Lordship,
the
it's, the
arbitrator.
petitioner, they have also written to the union 2 or 3 times. I have also forwarded the court's order.
My clients took the copy all the way to Delhi to serve the dusty service also, Your Lordship.
5, order dated 6/5/24
Yes,
also.
Lordship.
Mm.
I have sought instruction on a number of occasions, so I am helpless now. So I leave it to Your Lordship.
Or they can also suggest somebody.
Yes, your
Yes.
lordship, we're not averse to that, but in any case, even if the union is not responsive, your lordship, once the arbitrator is appointed, if they don't appear before the arbitrator, your lordship, it is their own, to their own demise.
A prayer has been made on behalf of Mr. N. Nangami, the learned senior government advocate appearing in this matter, to list the matter after some time as he is on his legs in court number 1. Stop. At this point, the learned counsel for the petitioner has stated that the only issue to be decided here is the appointment of the arbitrator, and right order dated 6/5/2024, the learned counsel for the petitioner had already proposed the name of Mr. Justice B.K. Sharma, retired judge of the Gauhati High Court, as the sole arbitrator. Stop. Therefore, the only issue is as to whether the state respondents and
The union
the
responded,
union
your lordship.
are agreeable to the said proposal. Stop. The learned counsel shall obtain necessary instructions and list the matter next week.
My lord,
Next week.
my lord,
Get specific instructions.
if some observation can be made, because this same subject matter, this same issue has been dragging on for a long time, so whether any instruction come or not, whether it will be in the interest of the parties to
There's
proceed with the
an
appointment.
observation on
My lord.
10/4/25 that the taking the into account the dispute, the parties would be at liberty to
Yes, your
get
lordship,
for
but that,
conciliation.
that observation
cannot
was
be
made, but that chapter is
closed.
long closed.
Lordship, I
Yes.
instructed to list this matter after some time. His lordship.
After some time. Okay, let's see then.
My lord,
Yes, just keep it. Yeah. We'll see
your lordship,
after some time.
my lord.
For admission, item number 5.
May I please, your lordship? My lord, kindly peruse the last order dated 24th of April 2025. That is the order passed on the last date of hearing. It is a matter of appointment of arbitrator. And my learned friend has come up with a letter that they are appointing the arbitrator. Now, my lord, I am referring to this Supreme Court, Honorable Supreme Court judgment. It says, after the filing of this petition under Section 11, the right cease. So it is only for the court to appoint the arbitrator. So I'll be praying that any retired honorable judge of the High Court may be appointed as the arbitrator. Because now the right to appoint the arbitrator with the parties has ceased, my lord, in view of this judgment. My lord, may kindly refer to para 5 of this judgment, 2006 to SCC, page 638.
Para 5.
Yes, my lord. May I read, my lord?
Yes, please read.
Having heard the learned counsel for the parties, we are satisfied that the appeal deserves to be allowed. The learned counsel for the appellant has placed reliance on the law laid down by this court in the case of Datar Switchgears Limited versus Tata Finance, wherein this court has held as under. So far as Section 11.6 is concerned, if one party demands the opposite party to appoint an arbitrator and the opposite party does not make an appointment within 30 days of the demand, the right to appointment does not get automatically forfeited after expiry of 30 days if the opposite party makes an appointment even after 30 days of the demand. Here it is not the case. They did not appoint. But before the first party has moved the court under Section 11, that would be sufficient. In other words, in cases arising under Section 11.6, if the opposite party has not made an appointment within 30 days of demand, the right to make appointment is not forfeited but continues, but an appointment has to be made before the former files application under Section 11 seeking appointment of the arbitrator. So, my lord, here the time has gone, my lord, for both the parties. Though I proposed one, then after filing this petition, they proposed one. So, as per this judgment, the right to appoint the arbitrator ceased, my lord. Now it is for the court, and I'll humbly pray that any retired High Court judge may kindly be appointed as the arbitrator.
Oh, you had appointed an arbitrator.
Yes, from the side of the department. However, since as per this
But as
judgment,
per this judgment, yes.
yes, maybe on the verge of the court may be on the verge of appointing the arbitrator. However, in the interest of justice, can you grant me a few weeks time to consult the department once before this on the court pass any order? If it may be listed next week.
No, you informed them about this judgment. and
Not
say
yet,
that-
not yet. So
Not yet.
Not yet.
Uh,
So just 1 week.
Next.
Next,
Pending since long, my lord, 1st of October was the first date. And my lord, the order is 24th of April 2025, specifically saying so that the Learned Council will go
1
through
week.
this
He's only asking for 1 week.
as my lord, sir, as my lord, sir.
Mr. K. Angami, Learned Assembly Kohima advocate, has submitted that the respondents have not been intimated about judgment of the Supreme Court reported in 2006 to SSC 638 and therefore prays for 1 week's time to get specific instructions after consultation with the respondents. Prayer is allowed matter after 1 week. Learned Council, you're Mr. Amit Parashar.
Amit Parash.
Amit Parashar, Learned Council petitioner is present. And here you are.
Please, my lord. I am in Chandigarh, my lord.
No, no. Another
another case.
Oh, another case.
My lord may say positively
After
they will
1
do
week.
it.
Yes.
My lord may say positively they will do it.
You make sure that yes.
I'm so grateful. I'm so grateful.
Yes.
Item number 6.
Let me. My lord, I am appearing for a petitioner. My lord, this is a matter for quashing under section 482. My lord, what happened, my lord, the petitioner is farm company is a Jorhat, and they are purchasing, my lord, masoor dal and chana from the respondent, my lord. Now they made advance payment, my lord, and they have to get much various, my lord, amount. They did not supply the goods for which they filed a suit in the court of Jorhat, my lord. This is a commercial suit that is going on. Now, my lord, in order to circumvent that, my lord, they lodged this FIR, which is at page 22. You'll also see it's a civil dispute, my lord. How it can come to the criminal matter, my lord?
Are you filing any objection?
It is covered by various Supreme Court judgments also.
What about respondent number 2? Service.
Once appeared, my lord,
Appeared by Otem.
but subsequently it appears they are not interested because it's a civil dispute. 18/6/24, my lord. Your losses must see the order. 18/6/24, they appeared.
The complaining counsel is also represented by one Otem Jinjamed Lordship.
O Tenzin. Temjem. O Temjem appeared on behalf of the national.
18/6, yes, 18/6 they had appeared.
Yes. They appear, my lord, it is on the face of it, my lord, it's a civil dispute, my lord. It does not come within the purview of, my lord, criminal. There are series of judgments of Supreme Court.
The name reflected in the cost list.
It is reflected, Lord.
Yes.
It is reflected in the cost.
Today, when the matter is called, the Learned Counsel, Learned Senior Counsel, GN Sahiwala,
My lord, yes, from Gauhati.
assisted by Mr. P. Teka. Stop.
Yes. E Decca.
P. Teka. Okay.
P.
Teka. P. Yes.
Not P, my lord, D.
D.
D for Delhi. D for Delhi. D for
D.
Delhi,
Teka.
yes.
Assisted by Mr. D. Teka. Stop. Learned PP, Mr. Vito V. Zimomi is present. Stop. However, none appears for the respondent number 1 when the matter is called. Stop. On 18th.
Two, my lord.
No,
That's not two.
respondent number 2. On 18/6/2024, Mr. O. Temjin Jamir learned counsel had appeared for the respondent number 2 and prayed for 3 weeks' time. Receive instructions. Stop. Accordingly, let's give them another chance. Accordingly, list the matter after 3 weeks.
My lord,
And if they don't appear, we'll take it up.
my lord.
Yes.
Any date can be given, my lord?
On list the matter after 3 weeks. On which date, if the respondent number 2 is not represented, the matter will be heard on the basis of records available before the court. So, list the matter after 3 weeks. Any interim?
Yes, interim is there, my lord. Interim is continuing.
Interim order passed earlier shall continue till the next date.
A date may be fixed, my lord. That will be better.
When? 3 weeks.
Maybe the, my lord,
Fifth
July.
June. 5th June.
June.
Yes.
Yes.
Or 9th June.
All right.
Fix the matter on June.
Night.
For admission item number 9.
May it please, my lord. Lordship, I have received a letter dated 13/5/2025 this morning inside the courtroom, Lordship. So I may kindly be granted a week's time to seek instruction on this, and the matter can be listed next week.
Lordship, I am appearing on behalf of the Income Tax Department, my lord. And in fact, Lordship, we received an instruction from the department that the respondent number 2, my lord, there is no post as such, my lord. Respondent number 2, my lord. So, my lord, the jurisdiction of the petitioner it lies with the, my lord, Income Tax Officer Ward 28-1 New Delhi. And he has not been made party, my lord. Unless he has been made a party, my lord, records are with him only, my lord, in the Delhi Commissioner, not with the, my lord, my lord, respondent number 2, my lord, as has been
Seek
mentioned.
further instructions on that, and if necessary, I may be allowed to file appropriate applications for amendment of the cost title.
That you pray later. For today, we are just.
Yes. Which is why, yes, I may kindly be granted a week's time.
Learned counsel for the petitioner, Sri Sinti Anger, has wait for 1 week.
Yes, my
For
lord.
week's time.
Or 2 weeks in order to be on the safe side.
Pray for 2 weeks' time, as he has received a certain communication from the respondent number.
The income tax officer, Ward 1 Dimapur.
The income tax officer.
Ward 1 Dimapur.
Ward 1 Dimapur. And he would like to obtain certain instructions with regard to the same. So, list the matter after 2 weeks.
Let the interim continue.
The interim order passed earlier shall continue to the next date. Learned counsel for you are?
Kenagi.
No, for whom?
My lord, he is assisting me, my lord. I am for the department.
Okay. And you are learned counsel? You are for the
I
income?
am, my lord, for the income tax department, my lord.
Okay. Your name?
My lord, Suman Chetia, advocate from Gauhati.
Chetia appears for the income tax department.
Deeply
My
offense.
lord, date may be fixed, lord. Currently on 38th, lord.
30.
Lordship.
8th of May. Yes.
Much
My
offense.
lord. All right.
For admission item number 12.
Please, my lady, I beg to appear for the petitioner in item number 12. My lady, this is a petition for quashing of an FIR dated 22nd May 2024. The FIR is registered under section 420 of erstwhile IPC.
Your name?
My lady, my name is Ayush Mitruka.
Ayush Mitruka.
It's appearing in the cause list.
Okay. Yes.
Yes, my lady. My lady, this is a petition for quashing of an FIR dated 22nd May 2024, registered with North Kohima Police Station under section 420 of IPC. Milords, before I show your ladyship the documents briefly put, Milords, the FIR has been filed by a retailer who supplies food and other beverage products. I am, Milords, a distributor who takes the goods from the manufacturer and supplies it to the complainant or the retailer, Milords. Milords, in a nutshell, the allegation against me in the FIR is that from 2013 onwards, I have supplied substandard or expired goods to the complainant, and that a loss of about 40 lakhs, Milords, that's the allegation in the complaint, has been incurred by the complainant. Milords, that's broadly the allegation. If my lady may kindly see the copy of the FIR, and we have also filed a typed copy. My lady will kindly see the typed copy of the FIR. This is...
Page?
Milords, there's a separate affidavit filed, my lady, with a typed copy. This is, my lady, affidavit of 17th March 2025.
Yes, 17th March.
Yes, my lady will kindly come to Annexure 2, page 11. This is the complaint that was filed by the complainant.
Annexure A2.
A2, my lady.
Yes.
Yes, my lady, if I may read out with your permission. With utmost respect, I, so-and-so, on behalf of so-and-so, engaged into business as a distributor with AK Jain Sales and Marketing Private Limited. My lady may kindly note, from 2013 till date, on implied, confirm and valid order, where on the condition that the expired, damaged will be recovered. During the course of performing my duties, I had received damaged expired goods, which was deemed acknowledged by the company through its representative. However, even after continuous claim for damaged expired items for outstanding disputed amount of about 40 lakhs, the company representative, on the pretext of several reasons, did not pay heed to replace the damaged products or credited the pecuniary loss being incurred with effect from 2013 again, my lady. This FIR is filed in 2024. The allegation is from 2013. Kindly note that, my lady. In fact, that they have acknowledged the damage notices to these effects, they had paid lip service to compensate. However, no such payments are made. The company and its agents are playing mischief under nefarious schemes with the intent to cause loss to my business and reputation in the estimation of my customers. The company and agents, even after knowing fully, passing the buck to each other to circumvent the possibility of delivering the products which are damaged or compensated the damage. The deliberate action of the company and its agents has eminently endangering my existence to engage in any business undertaking and outrightly damage my reputation in the estimation. I therefore beg your esteemed authority to take cognizance. Milords, this is the FIR that has been lodged against me. My lady has seen that the allegation starts from 2013 onwards, and the only allegation against me is that certain damaged or expired goods were supplied to him. Now, my lady may kindly see one legal notice that came from the complainant himself on 23rd December 2023, which is about few months before the FIR. My lady, that is at page 67 of the petition.
Yes.
Page 67, my lady has it.
Wait, FIR is dated.
This FIR is dated 22nd May 2024
2024.
under section 420 only. And my lady may also kindly note that there is only one accused named in the FIR, which is AK Jain's Sales and Marketing Private Limited. That is the company.
Yes.
Yes, my lady will have kindly page 67 of the petition.
The legal notice.
Yes, my lady may kindly note the date on the top right-hand side, 23rd December 2023. This is complainant's own document, which the complainant, of course, does not make any reference to in the FIR that he files. But my lady will see that there is a completely different story that he makes here. My lady may kindly come to page 68, the next page. If I may read, my lady.
Yes.
Para 1. That my client engaged in the business as a dealer against your valid and conforms order from the year 2013 till date. That my client in the course of performing his duty received damaged and expiry products that was acknowledged by a sales representative. That the yearly wise damaged expired products recorded are highlighted in the table below. Now my lady will see the table. This is very interesting. The table, my lady, has transaction from November 2013 and the last transaction is March 2019. There is no transaction after that. And my lady will also see the total amount that he is claiming in the legal notice. This is 38,07,000. This is different from what the amount he states in the complaint that is filed after few months.
In the FIR, it is 40 lakhs. 40 lakhs.
Yes, 40 odd lakhs, my lords, and here it's 38,07,000. There is almost a gap of 2 lakh rupees. And the second point, my lady, I want to emphasize on is the dates given in this table, my lady. This is from 2013 to March 2019 only. That's the only allegation. The FIR, my lords, deliberately, he doesn't put any end date because he knows if he says that the last transaction happened in 2019, the first question that will be asked as to why are you coming in 2024, almost after 5 years. But be that as it may, the legal notice of the complainant himself shows that the last transaction is 19. So assuming this is true, there is a delay of at least 5 years if I calculate it from the last transaction. The other question, of course, my lady, is if he was supplied damaged goods from 2013 continuously, why did he not once raise a grievance in the period that was relevant? But be that as it may, my lady may kindly see the notice what he says after that. There is no allegation of criminality at all. My lady will see para 4. That in spite of acknowledging the liability of payment of 38 lakh odd rupees, you have miserably failed to make payment of the said amount of due to my client from deliberately with an intent. Thus, you are liable to pay the total amount to my above client. And my lady, in the end, he asks me to make a payment of within 30 days, failing which he says he will file a civil suit. Now, my lady may kindly have page 71.
Yes.
So, Milad, I respond to the first legal notice, I deny the liability. Then he sends me a second legal notice. The second legal notice is at page 71. This is of 8th January 2024.
Yes.
Yes, my lady has page 71.
Yes, page
My lady,
71.
the date on the top, of course, there is a typographical error. The correct date, my lady, will find at the end of the notice at page 73.
8/1/24, yes. It should have been 8/1/24.
Yes, my lady. So this is the second notice, and my lady will see at page 73, the same table is there. He's again saying 38 odd lakhs till March 2019. So my lady, 2 legal notices were sent. His allegation in the legal notice simply was for demand of payment, civil dispute. I responded, my lords, to both legal notice. I said that once goods have been given, I cannot take it back. In any event, it is the manufacturer. Because I am not the manufacturer is somebody else. And my lords, the manufacturer is also named in the complaint, but he is not named in the FIR, which is Pran Group, PRAN Group, who's supplying all the goods to me. And then in turn, I supply the goods. So essentially, I am only a middleman. Now, my lady, ordinarily in a situation like this, one would expect that the complainant will file a civil suit for recovery. Now, the reason why the complainant did not file a civil suit and preferred a complaint, there are 2 main reasons. One, my lady, the last transaction admittedly by the complainant himself happened in 19. So he would have been out of time. He would have been barred by limitation. So he did not file the civil suit. Number 2, he of course would have also had to pay court fee on that. So my lady, instead of going down the appropriate course of action in this matter, what the complainant does is after 3 months, he has filed an FIR against me. Now, my lady, one last document, if I can show to your lady.
Yes.
My lady will kindly come to page 50. This is, my lady, a certificate of incorporation of when the company was registered. And my lady will kindly see the date. It says 27th day of May 2016. So therefore, my lords, the entire case of the complainant is made up. It's evident from this very document because my company came into existence only in 16. Whereas the allegation today is that I have supplied from 2013 onwards till 2019. That cannot be the case. And my lords,
Where is it? 26. Okay, given under my son.
yes, my lady.
27th May.
2016.
27th.
This is, my lady, a government document. My lady, this can be verified on the website of Ministry of Corporate Affairs, unimpeachable, admitted document. My transaction with the complainant only started in 2019. And my lady, if I may just draw your attention to page 119. So there are certain ledger accounts that I have put before your ladyship for consideration. My lady may kindly have 119. So my lady may kindly first note this is for a period from 1st April to 31st March 2020. And my lady, I am not taking your ladyship through the transaction, but the only point I am trying to make is that there was continuously supply of goods and the complainant continued to make payments. My lady will see there are credit amounts also on the right-hand side. So if someone was being supplied damaged goods, it cannot be assumed or it is beyond doubt that he will continue to make payments to me. And my lady, the last ledger account is of 31st March 2022, which is at page 122. My lady has 122.
Yes.
My lady will kindly note in the end, there is a closing balance of about 2,25,509. My lady can see that last figure. The difference between debit and credit.
Okay, yes, yes.
My
This
lady and my lady may
28 Feb 22. against this?
Yes. Yes, my lady. So this is in fact my position today is, as per my own ledger, that there is an outstanding amount of about 2.25 lakh that the complainant has to pay me. And because he refused to pay, he concocted a story and filed an FIR. So, my lord, these are the main documents that I want to show to your ladyship. Now, in view of the documents, I have prepared a short submission on law points, and my colleague, Mr. Peter, is there. If I can request him to hand over a short submission to my lady.
Yes, it's already here.
Yes, my lady has that written submission. My lady, this is only for your convenience that I have prepared. My lady may come straight to page 3, para 9. My lady, first 2 pages are the facts there. I'm not troubling your ladyship, but I've put it in writing so that it's there. My lady will have para 9, page 3.
Yes.
My first submission, my lady, is that the FIR does not even disclose prima facie the necessary ingredients to make out a case of section 420 IPC. My lady knows that the key ingredient of 420 is to at least make an allegation that you had a dishonest or fraudulent intention right from the beginning of the transaction. So in this case, if we were to assume that the complainant's case is true and correct, he should have at the minimum made an allegation against me that I had a fraudulent intent from 2013 onwards. That, my lady, is missing. And my lady, I have relied on 2 judgments of the Supreme Court, which are quoted there.
Yes.
The next submission, my lady, is that this is purely a civil dispute. At best, my lady, this can be a breach of contract. And for breach of contract, my lady knows the remedy is to file a civil suit and not a criminal complaint. That's point number 2. My lady, the point number 3 is, like I mentioned earlier, there is an unexplained delay of at least 5 years. The legal notice clearly says that the last transaction happened in 19, and I am assuming it that he is correct. What is the explanation or justification to file an FIR in 2024 after almost 5 years? There is absolutely no justification. So, my lords, the third point is that there is a significant and unexplained delay of over 5 years. My lady, the fourth point is that there is an inconsistent position and there is a suppression by the complainant because in the 2 legal notices that were sent in December and January, he says that the transactions happened from 13 to 19. The outstanding amount is 38 lakhs. But in his criminal complaint that he files in March, which was registered in May, he's saying that the damaged goods losses cost to him is 40 lakhs plus. So, my lords, the story that the complainant himself makes is contradictory. It's not consistent from his own documents. That's my lady, fourth and fifth point. And my lady, again, I have relied on a Supreme Court judgment. My lady will see at page 4, which is Mahmood Ali versus State of UP.
Wait, respondents are also here, no?
My lady, the state is here, but the complainant has not represented. He's not appeared before my lady. The service is complete. That's recorded in the order of 30th January 25.
Okay. Yes, please proceed.
Yes, my lady will kindly see page 4. The judgment that has been relied on is Supreme Court Mahmood Ali versus State of UP. Milords, may I just read this paragraph? One paragraph is important.
Yes.
This is quoted here, and I'm reading paragraph 12, which is quoted in my submissions itself. At this stage, we would like to observe something important. Whenever an accused comes before the court invoking either the inherent powers under section 482 of the CRPC or extraordinary jurisdiction under Article 226 of the Constitution to get the FIR or criminal proceedings quashed, essentially on the grounds that such proceedings are manifestly frivolous or vexatious, or instituted with ulterior motive for wreaking vengeance, then in such circumstances, the court owes a duty to look into the FIR with a care and little more closely. We say so because once the complainant decides to proceed against the accused with an ulterior motive for wreaking personal vengeance, then he would have ensured that the FIR complaint is very well drafted with all the necessary pleadings. The complainant would ensure that the averments made in the FIR complaint are such that they disclose the necessary ingredients to constitute the alleged offense. Because in this case, my submission is that the necessary ingredients are also not there. But be that as it may, my lady may see what the Supreme Court has said. Therefore, it will be not just enough for the court to look into the averments made in the FIR complaint alone for the purpose of ascertaining whether the necessary ingredients to constitute the alleged offense are disclosed or not. In frivolous or vexatious proceedings, the court owes a duty to look into many other attending circumstances emerging from the record of the case over and above the averments. And my lady, that is the reason I showed your ladyship the legal notice, the certificate of incorporation, and the ledger accounts. Circumstances emerging from the record of the case over and above the averments, and if need be, with due care and circumspection, to try and read in between the lines. The court, while exercising its jurisdiction under Section 482 of the CRPC or Article 226 of the Constitution, need not restrict itself only to the stage of case, but is empowered to take into account the overall circumstances leading to the intention registration of the case, as well as the material collected in the course of the investigation. So, my lady, I am relying on this judgment to rely on other documents, and most of these documents are either unimpeachable, clear documents, or the complainant's own documents. My lady, the next ground is at page 6. That is, the petitioner company was itself registered in 2016, and therefore it is impossible that the transactions have happened from 2013 onwards. 7th, my lady, the statements of the petitioner do not match. And my lady, the last ground is that the allegations made in the FIR are all general and vague. There is absolutely no specificity or specific allegation that the complainant makes. And that's one of the key grounds, my lady, because the Supreme Court has time and again said, as my lady knows, that you have to make a specific allegation against individuals who are responsible for the criminal act. You can't simply say that the accused or their representatives, without naming anyone specifically as to what their role is, what have they done, how is their involvement in the case. So, my lady, there is no specific allegation at all. So, broadly, my lady, that is my case today. One of the objections that, my lady, the learned public prosecutor had raised in the earlier occasion was that I was not cooperating and I have not given my statement. Milords, my statement has been recorded by the IO on 12th of May 2025. And my lady, one other objection that the learned PP had taken is that the investigation is at a nascent stage, and therefore a quashing petition cannot be considered or decided. That, my lady, in my respectful submission, is a wrong submission. The fact whether the investigation is at an initial stage or not is not relevant while exercising a quashing jurisdiction, and I have, my lady, relied on a very recent 2025 judgment of the Honorable Supreme Court, which is at para 10 of my written submissions.
This 2025 SSC.
Yes, my lady, this is Imran Pratapgarhi versus State of Gujarat. And my lady, there are just one paragraph, if I may read out, which I have quoted also, and I have given a copy of the judgment. I'm just not troubling your lordship because everything is here. If I may read out, we fail to understand how the High Court concluded that the message was posted in a manner that would certainly disturb harmony. Thereafter, the High Court gave a reason that the investigation was at a nascent stage. There is no absolute rule that when the investigation is at a nascent stage, the High Court cannot exercise its jurisdiction to quash an offense by exercising its jurisdiction under Article 226 of the Constitution or under Section 482 of CRPC, equivalent to Section 528 of BNSS. When the High Court in a given case finds that no offense was made out on the face of it, to prevent abuse of process of law, it can always interfere even though the investigation is at the nascent stage, it all depends on the facts and circumstance of each case as well as the nature of the offense. There is no such blanket rule putting an embargo on the powers of the High Court to quash FIR only on the ground that the investigation was at a nascent stage. If such embargo is taken as an absolute rule, it will substantially curtail the powers of the High Court, which have been laid down and recognized by this court in the case of State of Haryana versus Bhajanlal. And my lady, on the next paragraph, my lady will note, I have clearly stated that on 12th April 2025, I have anyway joined the investigation. My statement has been recorded virtually. My lady, one last point before I conclude. There is an order initially passed by your lordships, which granted me some interim protection. That interim protection was valid till 30th of January 2025. On that date, this honorable court was pleased to decline to extend that interim protection. And my lady may kindly have that order for a minute. This is the order of 30th January 2025. Whereby the Honorable High Court was pleased to decline the extension of the interim order on the ground that I perhaps did not disclose all facts to the Honorable Court.
Order dated
30th January 2025.
Okay.
My lady, this order I have challenged in the Honorable Supreme Court. The Honorable Supreme Court has been pleased to grant me an interim protection that in the event I am arrested in connection with this FIR, then I will be released on bail. That is only for full disclosure that I wanted to mention, and I have stated this, my lady, at paragraphs 5, 6, and 7 of my written submission also. That order is a very specific order on interim protection, which I have challenged. The matter is today pending before the Honorable Supreme Court. Para 5, 6, 7, my lady.
in your written submission.
Yes, my lady.
Okay.
But my lady, my submission is that the pendency of the Supreme Court proceedings is on a very limited point. That pendency in any way will not come in the way of your lordships deciding this petition, because there is today no stay on the continuation of this quashing petition. So my lady, in light of these submissions, my humble prayer before your ladyship today is that the FIR must be quashed insofar as the petitioners is concerned. The main culprit, if at all, in this case has to be the manufacturer, because I am only a middleman who takes goods from the manufacturer and supplies it to all the retailers. And in any case, my lady, this is purely a civil dispute. And there are other grounds which I have already argued before my lady and also put it in the written submission. I should be given permission to rejoin in case any new point is raised by the learned PP.
Yes.
I am deeply obliged, my lady.
1 minute. The order regarding service on respondent number 2.
Yes, that's the 30th January, same order.
Oh,
That
same.
records 30th January 2025 of this honorable court records that the service has been made and the respondent has chosen not to appear. He's not appearing before the Supreme Court also. He's not appearing here also.
Yes.
Milords, that's also captured in my written submission at para 5 on the service portion.
I may be allowed to hand it over the updated CD, Your Lordship. Your Lordship here,
Yes.
Your Lordship here, the petitioner counsel has take Your Lordship to the complaint. The
Yes.
complaint prima facie disclosed a case of investigation, Your Lordship, that damaged good was supplied, and then they acknowledge it. They have acknowledged to compensate. They have acknowledged it and the damaged good to be compensated. So your lordship, a prima facie case reflective of dishonest intention can be made out from the complaint itself, your lordship. The allegation, whether it is true or not, the test cannot be determined at this stage, your lordship. The petitioner has raised the grounds of delay. Your lordship, I can safely say that there is no delay, your lordship, because they have been paying a lip service till the filing of the FIR. If your lordship will closely look at the complaint, your lordship. It's reflected in the CD, your lordship. May I have a look at page
You have
one?
marked the relevant portion, no?
Yes, yes, your lordship. Page one of the CD, updated CD, which I've handed over to them.
Page one.
Page one.
Yes.
I'll have to read the whole
Yes,
thing.
yes, this
With
is the
utmost
FIR.
yes, your lordship. During the course, your lordship, during the course of performing my duties, the last third line of the first paragraph. During the course of performing my duties, I had received damaged expired goods, which was deemed acknowledged by the company through its representative. However, even after continuing claim for damage or expired items for the outstanding undisputed amount of rupees 48,813 and 54 paisa only, the company representative, on the pretext of several reasons, did not pay heed to replace the damaged products, nor credited the pecuniary losses being incurred with effect from 2013 till today. That is the statement, your lordship. It is the fact that they had acknowledged the damage notices to these effects. They had paid lip services to compensate. However, no such payments are made. The company and its agent are playing mischief under nefarious schemes with the intent to cause loss to my business and reputation in the estimation of my customers, vice versa, the public. The company and agents, even after knowingly passing the bucks to each other to circumvent the responsibility of delivering the products which are damaged, nor compensated the damage. Your lordship, this itself becomes a matter of investigation, your lordship. So the contention raised by the petitioner, those are all subject of investigation, your lordship. And as I said, it cannot be determined at this stage, your lordship. And even the top court
the
recognized.
other materials which the petitioner has enclosed, like for example, the ledger and then the legal notice.
So that's why this
Yes.
these are part of the investigation. This will be a part of the investigation, and the investigation should allow to come to a conclusion, your lordship. It is too premature. Your lordship, in support of my submission on the earlier occasion of, I have handed over a Supreme Court ruling, Somjit Malik's case, 2024 case. Yes, your lordship.
There is one Mahmood Ali, then Somjit Malik, Naresh Kumar.
Yes, yes, that's
This one.
case. Somjit Malik's
Somjit
case.
Malik.
Yes. The ratio laid down in this case, I'm relying on this three paragraph, your lordships. Paragraph
Sorry,
six.
can I request the learned PP to give the citation so that I can see?
Somjit Malik versus the state of Jharkhand.
I'm great.
This is, give the criminal appeal number.
Lordship?
No,
It's
2024.
an SLP number. Yes, it's an SLP. Number 6583 of 2024, your lordship.
Yes, I have that.
So your lordship, may I take your lordship to para 16, 17, and 18?
Yes.
May I read your lordships? Before we proceed to test the correctness of the impugned order, we must bear in mind that at the stage of deciding whether criminal proceeding or FIR, as the case may be, is to be quashed, at the threshold or not. The allegation in the FIR or the police report or the complaint, including the materials collected during investigation or inquiry, as the case may be, are to be taken at their face value so as to determine whether a prima facie case for investigation or proceedings against the accused, as the case may be, is made out. The correctness of the allegation is not to be tested at this stage to commit an offense unless the penal statute provides otherwise. Mens rea is one of the essential ingredients. Existence of mens rea is a question of fact, which may be inferred from the act in question as well as the surrounding circumstances and conduct of the accused. As a sequitur, when a party alleged that the accused, despite taking possession of the truck on hire, has failed to pay higher charges for months together while making false promises for its payment, a prima facie case reflective of dishonest intention on the part of the accused is made out, which may require investigation. In such circumstances, if the FIR is quashed at the very inception, it will be nothing short of an act which thwarts a legitimate investigation. It is tried law the FIR is not an encyclopedia of all imputations. Therefore, to test whether an FIR discloses commission of a cognizable offense, what is to be looked at is not any omission in the accusations, but the gravamen of the accusations contained therein to find out whether prima facie some cognizable offense has been committed or not. At this stage, the court is not required to ascertain as to which specific offense has been committed. It is only after investigation, at the time of framing charge, when materials collected during investigation are before the court has to grow an opinion as to for commission of which offense the accused should be tried. Prior to that, if satisfied, the court may even discharge the accused. Thus, when the FIR alleges a dishonest conduct on the part of the accused, which if supported by materials would disclose commission of a cognizable offense, investigation should not be thwarted by quashing the FIR. So, Your Lordship, accordingly, the appeal is allowed. Here, the High Court has quashed the FIR, whereas in this SLP, that has been set aside, Your Lordship. So, Your Lordship, the present case squarely covered is, the ratio laid down in this case is squarely covered the present case, Your Lordship. And Your Lordship, the petitioner has filed this petition only after the free notice has been sent to him, and then only after the MBW was issued, Your Lordship. And he is not cooperating, Your Lordship. Just that when the top court recognizes that there is a case for investigation, and Your Lordship, I have the order with me, the Supreme Court order. The petitioner has approached the Supreme Court, and then even the Supreme Court recognizes the statutory right of the investigation here. The first order is page 28. And the second, this is the latest order, second document. Your Lordship, you can take the rest.
28.3 is the bill.
Your Lordship,
Bill, and then
yes,
22.5.
for the accused to appear. 2nd of May is for the accused to appear before the IO.
This is order dated 2/5.
2/5. This is the latest order of the Supreme Court, Your Lordship. For Your Lordship, even after the direction from the Supreme Court, the petitioner has failed to appear physically. He has appeared through virtually. But then according to IO, that is not satisfactorily. That is not satisfactory. So, Your Lordship, again, the court has directed the accused to appear on 10th of June, Your Lordship. So at this stage, the FIR should not be quashed, Your Lordship. And the Somnath Malik's case clearly covers the present case.
Is this a scanned copy?
Yes, yes, that's a
Yes, I
scanned
think-
copy. Yes, yes, yes.
Yes. Any
Yes,
reply?
my lady. My lady, very quickly, there are 3 or 4 points that the learned PP is raised. The first one is that the delay has been explained. And how the learned PP seeks to explain the delay is because the FIR says that the representatives continue to assure. Surely, my lady, that assurance can't be for over 5 years. And my lady has already seen the complaint filed. There is no specific mention of who was the representative, where is the acknowledgement. Even my lady has the case diary now. I am not sure if the complainant has given any acknowledgement to the police, which shows that the company or its representatives have acknowledged any damaged goods. But be that as it may, even if there is something and I assume it against me, my lady, this is a pure case of, at best, a breach of contract. In that situation, how does someone get the right to file a criminal complaint? And my lords, the only agenda of this criminal complaint is to harass me, so that I am completely at the mercy of police. I am running behind, giving statement, etc. So that's on first point. Second, my lady, I am not disputing the proposition of law that the learned PP has canvassed before your lordship. I agree that it is a settled position that in the case of quashing, the FIR should be taken at its face value. But my lady, what also needs to be considered is that if there are attending circumstances or if there are complainant's own documents which tells a different story where there is a contradiction, in that case, my lady, the Honorable High Court cannot ignore all of those things. On the face of it, my lady, this will show that the FIR is malified and that the complaint has been registered as an abuse of process. And my lady, in this context, very recent April 2025 Supreme Court judgment, my lady, that's there in the written submission, if my lady kindly has that. This is Rika Birani versus State of Uttar Pradesh. It's a short judgment, my lady, of about 14, 15 pages. My lady may kindly see page 4. That doesn't have paragraph number.
After 5 minutes.
Please, my lady.
Next, item 3 there. Wait,
Yes, you were referring to?
Rikab Birani versus State of Uttar Pradesh. This is an April 2025 judgment of the Honorable Supreme Court. My lady may kindly come to page 4 of that judgment, internal page 4.
Yes.
Yes, my lady, if I may read third last paragraph onwards, we are constrained to pass this detailed speaking order. My lady has that?
Yes.
Yes, if I may read, my lady. We are constrained to pass this detailed speaking order as it is noticed that notwithstanding the law clearly laid down by this court on the difference between a breach of contract and a criminal offense of cheating, we are continuously flooded with cases where police register an FIR, conduct investigation, and even file charge sheet in undeserving cases. During the last couple of months, a number of judgments, orders have been pronounced by this court, especially in cases arising out of the state of Uttar Pradesh, deprecating the stance of the police, as well as the courts in failing to distinguish between a civil wrong in the form of breach of contract, non-payment of money, or disregard to and violation of contractual terms, and a criminal offense under section 420 and 406 of IPC. The ingredients of which are quite different and requires mens rea at the time when the contract is entered into itself to not abide by the terms therefore. In Lalit Chaturvedi versus and others versus State of Uttar Pradesh and another, this court quoted an earlier decision in Mahmood Ibrahim and others versus State of Bihar and another, wherein referring to section 420, my lady, our case also deals only with section 420. It was observed that the offense under said section requires the following ingredients to be satisfied. Let us now examine whether the ingredients of offense of cheating are made out. The essential ingredients of offense of cheating are as follows. So the bare minimum, my lady, that there has to be these allegations. 1, deception of person either by making a false or misleading representation or by dishonest concealment or by any other act or omission. 2, fraudulent or dishonest inducement of that person to either deliver any property or to consent to the retention thereof by any person or to intentionally induce that person so deceived to do or omit to do anything which he would not do or omit if he were not deceived. And this is important, such act or omission causing or is likely to cause damage or harm to the person in body, mind, reputation. My lady will then have page 6. I am not reading the next judgment. My lady will straight away have page 6. This court, my lady has that?
Yes.
This court, Delhi Race Club Limited and others versus State of Uttar Pradesh and another, highlighted the fine distinction between the offense of criminal breach of trust and cheating, observing that the two are antithetical in nature and cannot coexist. Police officers and courts must carefully apply their minds to determine whether the allegation genuinely constitute the offense alleged. In Kunti and another versus State of UP, this court referred to so and so, wherein it was observed that a breach of contract does not give rise to a criminal prosecution for cheating unless fraudulent or dishonest intention is shown at the beginning of the transaction. So, my lady, if I take it that the complainant's case is right, then at the least, he should have alleged that there is a fraudulent intention from 2013 onwards. That's the starting point, my lady, in the FIR. That is completely unbelievable. And my lady, the Supreme Court is clear. Whenever there is a case of cheating, the dishonest intention should be shown from the beginning. It cannot be the case that I have had a dishonest intention from 2013 till 2025 when he finally, 24, I'm sorry, when he registered the FIR. And my lady, if I may read after, merely on the allegation of failure to keep a promise will not be enough to initiate criminal proceedings. This squarely answers the point that the learned PP raised. Even if I assume that there was some acknowledgement, which my lady, my case is that there is no acknowledgement, that at best will be a failure of promise for which he will have to file a civil suit. That is a breach of contract. Thus, the dishonest intention on the part of the party who is alleged to have committed the offense of cheating should be established at the time of entering into the transaction with the complainant. Otherwise, the offense of cheating is not established or made out. It is the duty and obligation of the court to exercise a great deal of caution in issuing process, particularly when the matter is essentially of civil nature. the prevalent impression that civil remedies being time consuming do not adequately protect the interests of the creditors or lenders should be discouraged and rejected, as criminal procedure cannot be used to apply pressure. Failure to do so results in breakdown of rule of law and amounts to misuse and abuse of the legal process. So my concluding submission is this, my lords, that I am assuming that everything said in the FIR is true and correct. Despite that, my lady, there cannot be a criminal proceedings basis what the complainant has filed with the police. So my respectful submission today before my ladyship is that this FIR must be quashed. If I am required as a witness or otherwise to cooperate with the police, I am undertaking before this honorable court that I will cooperate to the best of my abilities. I have already given a statement, and my lady, in fact, the Supreme Court has also protected me and said that you cooperate till the time this is going, my lords. I am ready to cooperate, but as the Supreme Court has also said, the fact that the investigation is at a nascent stage, etc., that cannot be a ground to not consider my quashing petition. I'm deeply obliged for a very patient hearing, my lady.
Third learned counsel, Mr. Ayush Mituka.
Yes, my lady.
And learned BP, you are also appearing, and Mr. Mary, Ayush Mituka and B. Mary for the petitioner, stop, and learned BP, S. Mary for the state respondents. Orders reserved.
I'm sorry, my lady is reserving judgment on this?
Reserving.
Yes, my lady. Grateful, my lady, grateful. My lady, may kindly also add my colleague's name, Mr. Suresh Kumar Mitruka. His name is there in the cause list also. My
Okay.
lady, may kindly add that.
Put that also. Yes.
Suresh Kumar Mitruka.
Yes.
I'm deeply obliged, my lady.
For admission, item number 13.
May it please your lordship. By this petition, I'm praying for the pre-arrest bail. Lordship, short fact, the case is that the petitioner and the wife, they got married in the year 2023. And after that, the brother and the father of my wife, took her to Nepal. And thereafter, the petitioner filed diverse petitions to live an independent life before the principal family judge Dimapur.
Wait, please repeat again the facts. You are?
Lordship, I'm the
Your
husband. Yes.
Okay.
Yes. So I filed the divorce petitions before the principal family judge court, Dimapur. And thereafter, the wife filed the FIR before the police stations on the allegation that I married another woman. Yes. And however, the parties are in a great position to settle the matter amicably. Yes, Lordship. So,
FIR was under what section? Let me see.
Lordship, I'm charged under section 82(1), 85, 351, 2 BNS, read with section 4 of Dowry Prohibition Act. Lordship, as I have mentioned in para 9 of my petition, there is an allegation from the investigating agency that I did not cooperate with the investigating agency. However, on 22/2/2025, the police station, they summoned me and my mother to the police stations, and I appeared before the investigation officer, and I was formally arrested. And I was released on the bail bond of rupees 20 and a local security. Yes. And regarding, there is an also allegation that there is a threaten from us, there is a threatening from a side to the investigating agency. However, there is a one contact number who called the IO. I did not know who is that person that called the IO. And since I'm the local resident of prominent resident of Dimapur district, I run a small business at Dimapur. So there is no apprehension that I will jump bail. So my anticipatory bail may be regularized, Your Honor.
Yes, Your Lordship. The IO has contacted me and so far the petitioners are cooperating, Your Lordship. That is what I'm informed, Your Lordship. So since they
Then
are
we
cooperating.
regularize the bail.
Yes, Your Lordship.
And this is actually arising out of matrimonial
Yeah,
dispute
yeah,
only.
that's true, that's true.
Third learned counsel for the petitioner, Shri such and such. Stop. It is submitted that the instant case has arisen out of a marital dispute between the petitioner and his wife, wherein the petitioner had filed a divorce petition against his wife before the court of the Principal Judge Family Court, Dimapur. Stop. While the said matter was pending for settlement, the wife of the petitioner lodged an FIR dated 5/2/2025. Where is the FIR page?
Lordship, I find it on page 22 to 27.
Under section 82+1/85/351 clause 2 of the BNS read with section 4. What is this DP or Dowry Prohibition Act? Stop. The petitioner has submitted that he is a permanent resident of Dimapur and hence there is no question of absconding or avoiding or evading the investigation process. He accordingly prays that he may be granted pre-arrest bail. So on, where is the interim order? Mm. Were you given any interim protection by this court earlier?
Yes, Lordship.
Dated? Order dated 1/4. This court, vide order dated 1/4/2025, had granted interim pre-arrest bail to the present petitioner / applicant with the condition that he shall cooperate and appear before the IO of the case as and when called for, and that the accused shall not directly or indirectly make any inducement, threat or promise to any person acquainted with the facts of the case, including the informant and her family members, so as to dissuade him / her from disclosing such facts to the court or any police officer. Stop. Learned public prosecutor Vivika has appeared for the state respondents and stated that the petitioner has complied with the above directions and has not violated any of the terms of the interim pre-arrest bail granted on 1/4/2025. Stop. This court has also produced the case diary and the inquiry report of the IO. Stop. Upon perusing the said documents and in regard to the facts and circumstances of the case, this court is of the view that the interim pre-arrest bail granted on 1/4/2025 can be regularized at this stage. Accordingly, the interim pre-arrest bail granted on 1/4/2025 is made absolute on the same terms and conditions. And the petitioner is directed to continue to cooperate with the investigation and appear as and when summoned by the IO. Petition is disposed.
Much obliged.
Item number 3.
May I please, my lord? Lordship, first of all, my sincere apology. I was on my legs in court number 1. So when this item was called earlier, I could not attend, your lordship. My sincere apologies for it, your lordship. Lordship, in this matter, what happened is that, your lordship, this matter was listed before this honorable court on 10/4/2025.
Yes.
And your lordship, I have made a submission basing on the contract agreement. There is a provision for conciliation. And therefore, I have asked this honorable court that if this honorable court can allow us to go for a conciliation. And therefore, this by order dated 10/4/2025 of this honorable court has granted us the liberty to go for conciliation process, your lordship. Now, my lord, from the respondent department, verbally they have informed me that they took step for conciliations and then they have said for it. However, the conciliation process has failed. That is what verbally they have informed. So now we are back to the arbitration again, your lordship. Yes.
So now are they agreeable to appointment of Mr. B.K. Sharma?
Lordship, for that matter, Lordship, since the respondent, state respondent, is the respondent to the chief engineer only, your lordship. It is not the government. And to take a decision by a chief engineer, your lordship, it is a little difficult. That is what they have expressed. However, your lordship, is some time can be granted because a communication has already been made to the government to whether the state respondent will be agreeable to the appointment of Justice retired B.R. Sharma as B.K. Sharma as arbitrator. So if a short date may be given to your lordship, so that I can get the necessary instruction and place it before this honorable court, my lord. Your lordship, I have one more submission to make, your lordship. The Union of India is also implicated in this matter, your lordship. Actually, the project belongs to them. And the project has been cancelled by them, your lordship. And therefore, all these arbitration petitions has come up, your lordship. If the Union of India can...
They have no instruction.
I don't remember the case, what are the real case? Union of India versus Kotigon. Here, Justice Deepasis Bora, he has directed the registry to furnish the name of the arbitrators that is approved by the High Court. In that case.
So that issue, your lordship, that issue has also been discussed. Now the issue has come to the point where the parties are agreeable to the sole arbitrator, that is Justice B.K. Sharma, that has been suggested by the petitioner. So we have to cross that first.
Yes, on 6/5/24, that order has been passed.
Yes.
So the respondent shall obtain necessary instruction in this regard and inform this court.
Yes.
So whether the respondents are agreeable to this or not.
Correct.
That
Yes.
was the that was
Correct.
the order.
Your lordship,
So
after that, the instruction that I received was for conciliation process. Yes, yes.
No, but now that has failed.
Now that has failed, your
Now
lordship.
you have to go back to
Yes,
this.
yeah, we are back to this.
But if Union of India is the main respondent, then
The project is sanctioned by them, your lordship, and subsequently again cancelled by them.
On 6/5/2024, this court had instructed the respondents to obtain necessary instruction as to whether the respondents would be agreeable with the proposal of the petitioner for appointment of Mr. B.K. Sharma, retired judge of the Gauhati High Court, as the sole arbitrator, or they would prefer to appoint another arbitrator from their side. Stop. Learned government advocate N. Nangami has submitted that another order had been passed by this court on 10/4/2025, wherein the parties were also directed to try for conciliation if so advised. Stop. Learned senior government advocate N. Nangami at this stage submits that the conciliation process had begun, but it failed. Stop. Accordingly, it is now. Accordingly, he has now prayed for some time to receive instructions regarding the appointment of the arbitrator. Stop. Learned CJC Younger Wati has also submitted that he has no instructions from the Union of India regarding the appointment of the sole arbitrator, and he also prays for some time to obtain instructions. Accordingly, list the matter. When?
2 weeks as a last chance.
List the matter of after 2 weeks. On which date the council for the respondents, the government respondents, as well as the Union of India, shall obtain necessary instructions regarding appointment of the arbitrator.
Your Lordship, if they don't come with the instruction, it has been going on for several years, more than a year, about a year, Your Lordship. So it may kindly proceed with the appointment of the arbitrator.
No, but if they don't agree to that, again, they will not appear. That is the problem.
If they don't appear, it is to their own demise, Your Lordship.
They
They
have to
cannot.
agree. They have to agree to it. It has
Then,
to be.
Your Lordship, then on the next date, at least some stringent order on this date, Your Lordship, unless some.
Just say, given
My
the
Lord.
2 weeks as a last opportunity.
My Lord. Blush, Your Lordship.
I'm deeply obliged, my lord.
For admission, item number 14.
Lordship, this is an anticipatory bail application arising out of a long transaction. Compromise agreement has already been executed on 13th of May.
Is this petitioner's statement is not in the case diary?
The FIR has also been withdrawn.
The fire withdrawn.
May I please, Your Lordship? My lord, I have received a letter from the IO. I'm informed that
Yeah, give it to-
the complainant has withdrawn the FIR, my lord, and settled the matter outside the court, my lord.
Then in that case, this
Yes.
petition is also infructuous.
Yes, my lord. Yes, my lord. So my only request is the agreement may be kept as Annexure X. Yes, and the anticipatory bail application may be closed.
Bernard, counsel for the petitioner, Sri Sinti Younger, has produced a copy of the agreement executed on 13th May 2025 between the petitioner and the complainant,
My lord.
by which the dispute between the complainant and the petitioner has been compromised.
In the
And-
page 2
and
top paragraph, it is mentioned that
is it-
FIR has also been withdrawn.
And it is also stated in the agreement that the FIR number 007/24 dated 1/10/2024 filed before the Women North PS Kohima against the petitioner has been withdrawn. So he accordingly states that the petition is infructuous and prays that it may be disposed of. However, the agreement dated 13 May 2025 may be kept on record. Stop. Next para. Learned PP Shri Thipapong has also produced a letter dated 14 May 2025 from the from the IO of the case, who has also stated that the complainant and the petitioner and the accused have reached a mutual understanding, and the complainant has decided not to pursue the case further and has also withdrawn the FIR. So, in view of the above stated facts and circumstances, this petition is infructuous and accordingly disposed of.
Much obliged. Much obliged. My lord, in item 33, similar order may be passed. Item 33 C is the calendar. Here, item 14 is the principal borrower.
Item 33.
The same FIR.
Item 33 also same order, but then petitioner's name will be different.
Much obliged.
Item number 34.
May it please your lordship. My senior Mr. T. is on legs, your lordship. The matter may kindly be passed over for attending, your lordship.
What is this anticipatory bid?
Yes.
Okay, pass over for the time being.
Obliged, your lordship.
Item number 35.
These 34 and 35
I
are
think it's the
numbers.
same, 34 and 35, please. After something.
For orders, item number 36.
Notices are complete.
Yes, Lord.
Other side is not there.
May I please, my lady?
Yes.
Lady, we have filed our wakalatnama. However, previous night it has come to the knowledge that there are some rectifications to be made in the wakalatnama, and it is already rectified and it is placed before the registry of this honorable court. So it may be listed after 3 weeks, my lord.
We can list it for hearing because
Yes.
the trial court records are also here.
Yes, my lord. Yes.
Pleadings are complete and the rectified wakalatnama has also been filed by the, you are for?
I am for the respondents. Respondent 1 and 2.
1 and 2.
For the respondent number 1 and 2.
My lady.
The trial court records have also reached. Accordingly, list the matter for hearing after 3 weeks.
After 3 weeks.
Lordship,
3
if
weeks.
it can be fixed on the 2nd of June. It's convenient for the respondent.
Should it be 3rd June?
My lady. Obliged.
For orders, item number 37.
Lordship, steps have been taken through registered post. But as per the court's office note, service is still awaited.
Learned counsel for the petitioner is present. as per office note, office note dated 13/5/2025 indicates that notice upon respondent 1 to 4 has been sent by registered post with AD. However, return service reports are awaited. So accordingly, fix the matter after 3 weeks awaiting service report on the respondents.
For hearing item number 38.
Your Leadership,
Such a thick file.
Your Leadership, if we start, we may not conclude today. Would your leadership be agreeable to having it part heard?
Lordship, lady, this matter.
And tomorrow is my last day.
But then if it is kept part, because in any case, it will not be possible to conclude in a day. The matter will be a bit lengthy. So if the counsel for the petitioner.
I am ready otherwise.
If the counsel for the
Subject to your
petitioner
leadership's
complete
convenience.
his submission today, then at the next day we can reply. Because I'm sure he will take just 2-3 hours.
Maybe longer
Yes.
than that. Because
So
the
in any-
facts are quite abundant, as you lordship already observed.
And
This is 2023. Because if we start today and then keep it part third, that it may come up only in June now.
Yes, Your Lordship.
June first week.
no problem, we can reply. The respondents, we can make our submission on the first review.
Okay.
May I please, Your Lordship. Your Lordship, maybe please to mention hearing item number 39 and 40, if it can be passed over for a day. Since this matter might take time.
Yes. 39
13,
and 40. Not,
39 and
not for the day, let come up next week.
Okay.
Next week, 39 and 40.
Much
Just say due to paucity of time.
Your Lordship,
Yes.
this is from the NIDC. And your leadership is well aware of the rules, but just to refresh ourselves, NIDC, the service rules. Before you go into the facts of the case, your leadership,
Yes.
can I take your leadership to the relevant rules first?
Okay, this is WPC 98.
And the rules of 1991. And the rules are called the Service Rules of the Nagaland Industrial Development Corporation Limited, 1991.
Yes.
So firstly, Rule 5. Chapter 2, Rule 5 at page 7 is the classification of posts. And Rule 6, your leadership, is the creation of posts. But just the head note first in Rule 5, your leadership. The posts under the corporation shall for the purpose of appointment, control, and discipline be classified as follows. So class 1, class 2, class 3, class 4. Why I am stressing on these rules, your leadership, is to draw the attention of this honorable court that there are no cadres as such, as far as the rules are concerned. There are no cadres. It's just one generally, just generally employees of the NIDC. Then the creation of posts. The power to create posts vests with the board. The board shall from time to time determine the number of posts of each description in the service of the corporation as per the corporation's service rules. And for this, there shall be a recommendatory committee constituted by the management. So the board's power to create posts. Then Rule 7. And this is important, your leadership. Sources of recruitment. Appointments shall be made through one of the following means. Or through one of the following. A, by direct recruitment. B, by promotion of the corporation employees. Ratio of A and B shall be on the basis of the ratio indicated in Annexure 1. That is a channel of promotion. C, by deputation from state, central government, and any other organization as may be directed by the board without disturbing the regular channel of promotion of the permanent employees of the corporation. So the only modes of entry into service. direct recruitment, promotion,
Promotion and
deputation. No other means. The recruitment from amongst the employees of the corporation by promotion shall be made if suitable candidates with requisite qualification experience are available. In case sufficient number of employees are not available for filling the post by promotion, these posts may be filled by direct recruitment, deputation from any other sources. In case of direct recruitment, preference may be given to the persons belonging to indigenous inhabitant of Nagaland. So the point is very important point here, Your Ladyship. The one is direct recruitment through the selection process, and one is promotion. These two cannot be interchanged. By promotion, no one can be directly appointed. That is exactly what has happened in this case. By promotion, no one can be directly appointed. The DPC has appointed someone directly. That is the first point to be noted, Your Ladyship. Then, Rule 7. Rule 7, we've gone through, Your Ladyship. Then, Rule 10. Authorities empowered to appoint. Then, direct appointment to the services of the corporation shall be made as follows. The posts of officers through service selection committee constituted for the purpose by the board. To any other posts other than officers through service selection committee constituted for the purpose by the managing director. So basically for gazetted officers by the board, service selection committee, and for non-gazetted officers, service selection committee constituted by the board, the managing director. I have been appointed by the service selection committee. The petitioner has been appointed by the service selection committee. The respondent, on the other hand, the private respondent, has been regularized in service. Not directly recruited, not a promotee who was of a person who was early in service, regularized in service. Then
you were directly recruited.
Yes, Your Honor. Yes, Your Lady, through the selection committee. And Rule 28 next, Ladyship. Seniority. Rule 28. Seniority of persons appointed to a grade shall be determined in the class of posts to which they are appointed by the date of joining of their posts. The inter-se seniority of persons promoted from the lower grade shall be maintained in the higher grade. This is also important, Your Ladyship. The inter-se seniority of persons promoted from a lower grade shall be maintained in a higher grade as well, except in cases of supersession. Inter-se seniority between direct recruits and departmental promotees appointed on the same day in a particular cadre post shall be 60% and 40% respectively. Direct recruits being given precedence over departmental promotees when such a situation arises. In case two or more persons appointed directly on the same day in the same class category of posts, the seniority shall be determined by merit only. So this is only in case of direct appointments. Yes. Otherwise, promotees are a different grade altogether. What is important here, Your Ladyship, is promotees, the seniority in the lower grade will be maintained. Rule 28 says. And it says, except in case of supersession. Now, except in case of supersession, that's a different issue. When persons compete for a single post and relative merit is assessed. But when two persons are promoted to two different posts, where is the question of supersession then, Your Ladyship? So in this case, the petitioner and the respondent, they were both given promotions on the same date. All along, the petitioner was senior in the lower grades. In the grade of GM, General Manager, promoted on the same day to two different posts, the DPC states that the private respondent is more meritorious and therefore she has been placed senior. Then, promotion at Rule 29. Elizabeth has got it, Rule 29.
Yes, Rule 29.
Promotion. For all category of posts, the basic criteria for promotion will be merit, suitability, efficiency, and past performance with due consideration for seniority. The minimum service in the lower post required for promotion to the next post shall be as indicated in the annexure. The criteria to determine merit, suitability, and efficiency shall be on the basis of performance appraisals, interview or written test, and also by assessing regular work. The appointing authority shall be competent to promote its employees through a DPC constituted by the board in case of officers and by the managing director in case of others. So a detailed procedure, though it is very short, a procedure has been notified as to how promotions are to be made. And promotion only in respect of promotional posts. Not for direct recruitment. Not for direct recruitment. And then another rule, which I must refer your ladyship to, is Rule 4. And this is a rule which the state is relying upon to say that my petition is premature.
Rule 4.
Rule 4. Rule 4 is at page 8. May I read, your ladyship? Rule 4 at page 8.
Interpretation.
Yes, yes. The power to interpret the rules vests in the managing director, who may issue such administrative instructions as may be necessary to the carrying out the purpose of the provisions of these rules. If any employee feels aggrieved as regards the interpretation of or implementation of any of these rules, she shall have a right to appeal to the board, whose decisions shall be final and binding on all concerned. The managing director, on the proper authority from the board, may delegate any of her power for the issue of such administrative instructions to an officer or a committee of officers of the corporation as she may from time to time specify. Now, what the NIDC, the state is saying, is that there is an alternative remedy. If I am aggrieved by any decision of the board, I should have resorted to filing an appeal. An appeal to the board. But the fact of the matter here, your ladyship, is the respondent was regularized on the recommendation of the board. His direct recruitment by the DPC was approved by the board. I cannot appeal against Caesar's orders to Caesar himself, let alone Caesar's wife. So that ground is a facetious argument, and that needs to be rejected at the threshold. So these are the rules which are holding the field, your ladyship, and these are the rules which govern service in the NIDC. Now, if we can go to the petition, the facts are bulky, so if I may refer to the paragraphs so that there's no confusion in the issue. At paragraph 4, beginning from paragraph 4, page 7. Paragraph 4.1. May I read, ladyship?
Yes, please read.
The particulars of the services of the petitioner and the respondent number 3 are listed below. A, the petitioner. By order number dated 8/10/1989, she was appointed as assistant manager on ad hoc basis. So initially joined as ad hoc basis. B2, on the recommendation of the service selection committee, I went through the selection process. By letter of appointment dated 10/5/2001 and by letter of regularization dated 24/7/2002, her service was regularized. 3, by order dated 16/8/2012, the post held by her, namely assistant manager legal, was upgraded to deputy manager legal. 4, by order dated 19/6/2017, on the recommendation of the DPC, along with others, she was promoted to manager. 4, by order dated 1/9/2020, on the recommendation of the DPC, she was promoted to deputy general manager. By order number dated 15/3/2023, she was appointed to general manager. B, the respondent number 3. We'll go through the orders later, your ladyship. B, respondent number 3. By letter of appointment dated 10/1/4/2005. So this is much after I entered into service. He was appointed as assistant manager on temporary basis. By order number dated 23/3/2010, his service as assistant manager was regularized. You look at the time lapse also, your leadership. Look at the time lapse also. 2002, I was appointed as assistant manager on regular basis. 2010, this person was regularized as assistant manager. not through any selection process. Not through any selection process. Then, next page, number 3. In the year 2012, one post of deputy manager which required a minimum length of service of 7 years in the feeder grade, that is assistant manager, fell vacant. He did not have the length of service for promotion to the said post. He applied to be appointed as a fresh candidate, and through a selection process held solely for him, by order dated 16/8/2012, he was appointed to the post of deputy manager. By order number dated 4/9/2012, his past service was ordered to be counted for the purpose of retirement. The order also shows that there is respondent number 3 as a departmental candidate directly appointed as deputy manager. So against a promotional post, he did not have the minimum length of service of 7 years. He was directly appointed by the DPC. We'll come to the document later on in addition. 4, by order dated 19/6/2017, on the recommendation of the DPC, he was promoted to manager along with the petitioner and others. Then, by letter dated 1/9/2020, he was promoted to deputy manager, general manager. By letter number dated 15/3/2023, he was promoted to general manager. Then, next page, at page 10, 4.2. In the year 1987, by order dated 8/7/97, the NIDC decided to redesignate existing posts of staff officers, assistant managers, and deputy managers for promotion from assistant manager to deputy manager. The NIDC laid down a minimum length of 7 years of service. In respect of the various categories of posts in the NIDC, notification number dated 19/9/2016 on cadre restructuring may be perused. So this annexure is important. So if you can go to this annexure at this point of time, and this is annexure 14. Page 52. This is the notification dated 19th September 2016. Consequent to approval of the recommendation of the Cadre Review and Organizational Restructuring Committee by the Board of Directors by decision dated 15 June 2017, various categories of posts vis-a-vis sanction strength, promotional channel, minimum education requirement for various posts in the corporation, and minimum span of service to be eligible for promotion shall be furnished in annexure 1, 2, and 3, and 4 attached to this notification. These changes come into force from the date of the board's approval, that is 15 June 2017, and supersede all earlier notification in these regards. So certain changes were brought about in the structuring of the NIDC. Next page, annexure 1. So the category of posts, as many as 21. The next page. Before we go to the next page, you will see there is no cadre that is mentioned here. It's just a general category of posts for the NIDC. There is no specific cadre, no differentiation in the service of the NIDC. No classification and no cadre. Next page, at page 54, promotion channel. So it starts from NIDC subordinate A, NIDC subordinate staff service, B, NIDC ministerial service, C, NIDC IT service, D, NIDC legal service, E, NIDC management service. So here for the first time, some sort of a classification is sought to be made out. And it says, assistant, so if you come to D and E, NIDC assistant manager, deputy manager, manager, E, NIDC management service, assistant manager, deputy manager, manager. The meeting point is DGM. From DGM, there is no classification. There is no classification. DGM, GM, and MD. And your leadership will kindly note, this is 2016. This is 2016. The petitioner, as well as the private respondent, were appointed much ahead of the issuance of this notification, much before any classification was brought about. And the state has taken the plea that the respondent was appointed in the management cadre. So-called management cadre did not come into existence until 2016. This is the point to be noted, Your Ladyship. In fact, this comes into effect from 15 June 2017 in terms of the notification, which is at page 52. And next page, at page 55. Minimum requisite qualification for appointment to various posts in the corporation. Minimum qualification for appointment to the post of assistant manager shall be MBA from a recognized university, master in economics, agribusiness, statistics, MTech, etc., etc. In exceptional cases, first class bachelor degree in the above streams may be considered. 2. Minimum qualification for appointment to the post of assistant manager legal shall be LLB, LLM, etc., with at least 5 years experience in legal profession. Minimum qualification for appointment in the post of junior assistant shall be bachelor's degree in any discipline with diploma in computer application and BCom and diploma in computer application for accounts assistant post. Minimum qualification for appointment to the post of junior assistant shall be bachelor of computer application or BSc, IT or equivalent. Minimum qualification for appointment to the post of steno grade 3, etc., etc. Then next page, page 56. Category of post, span of service. So junior assistant, 7 years, senior assistant, 7 years, assistant manager, 7 years. So 7 years to be promoted from assistant manager to deputy manager. So this was a practice which was already in force, which was just incorporated in this notification. This is the point, Your Ladyship. Then if we can revert back to the petition again at 4.3. In relation to the respondent number 3's appointment as deputy manager, the circumstances surrounding the same are germane. In the year 2012, one post of deputy manager fell vacant. The vacancy was made known to the respondent number 3 and some vested interest. In fact, Your Ladyship, as far as the promotion, the direct recruitment to the post of deputy manager is concerned, the records will clearly reveal how this respondent has been favored in total violation of the rules. The records are not available in before this honorable court today. The records can be called for and produced on the next day.
See. Records regarding the appointment.
Yes, the appointment, the entire service of the private respondent, including his appointment to the post of deputy manager. The vacancy was made known to the respondent number 3 and some vested interest in the NIDC. A minimum length of 7 years of service in the feeder post is required for promotion to deputy manager. He did not possess his eligibility criteria. Now, the interesting point of note, Your Ladyship, is that all these facts, they don't deny. But the ground taken is, I am in the legal cadre, he is in the management cadre, I don't have the local standard. That is the ground taken. By letter dated 17/7/2012, he applied for the said vacancy as a fresh candidate. Kindly note, as a fresh candidate. A circular bearing number dated 17/7/2012 was issued solely for his benefit, requiring him to attend the departmental promotion committee. Kindly note this. All this is admitted, Your Ladyship. Proceeding scheduled to be held on 21/7/2012. Based on his application, after appearing as the sole candidate by order dated 16/8/2012, the respondent number 3 was directly appointed to the post of deputy manager on the recommendation of the departmental promotion committee as a departmental candidate. His appointment to the post of deputy manager was on the basis of recommendations of an incompetent body and or a body having no authority in terms of the rules to make recommendations for direct appointment. This process in favor of the respondent number 3 is ex facie. Can we go to these annexures, Your Ladyship? Annexures 15 and 16. Page 57.
Yes. Application.
Application for the post of deputy manager as a fresh candidate. Kindly note that, Your Ladyship. As a fresh candidate. With due respect, I have learned that the departmental promotion committee, look at the language of the letter also, Your Ladyship, would be held soon for the post of deputy manager. And in this respect, I would like to offer myself as a fresh candidate for the said post. So he himself is applying for direct recruitment. With due respect in this regard, I would like to state that I have completed my Master of Business Administration and have work experience in various companies and projects, which is enclosed in the resume for kind reference. I would also like to state that the requisite qualification criteria and work experience for the said post, as stated in the service rules of the corporation, is in line with my qualifications and work experience. Thus, in this respect, I would be grateful if given an opportunity for your kind consideration, for which I would work for the corporation industriously. Having stated as above, and in accordance to the service rules of the corporation, I would like to apply myself as a candidate under direct recruitment. Look at that, your leadership. Category for the post of deputy manager, as the ratio for the post till date is being filled up on 100% promotion, whereas 50% of the post is to be recruited through direct recruitment. In reference to the above said matter, I would be grateful if you would kindly take the matter for your necessary action. The endorsement at the bottom of the page, your leadership. Please examine A above. If admissible, he may be allowed to sit, interview along with others. Then next page, at page 58. With reference to your application dated July 17, 2012, for the post of deputy manager, you are hereby directed to attend the departmental promotion committee shall be held on July 21st, 2012 in the office premises as follows. Written test for assistant manager and deputy manager, 10 a.m. to 11 a.m. Oral interview for manager, deputy manager, and assistant manager, 12:30 noon onwards. But this letter is very clear, your leadership. It was not placed before the selection committee. It was placed before the DPC. Then, can we revert to page 11 of the petition again, your leadership? Paragraph 5. That seniority lists were issued by the NADC from time to time. In the seniority list as on 16/9/2013, in the list of Group A officers, the petitioner is at serial number 17 and the respondent is at serial number 18. Kindly note the seniority position. I have been treated as senior all along, your leadership. In the seniority list issued on 18/8/2016, in the list of Group A officers, the petitioner is at serial number 12 and the respondent is at serial number 13. In the seniority list issued on 13/11/2017, in the list of Group A officers, the petitioner is at serial number 9 and the respondent is at serial number 10. In the seniority lists issued on 21/1/2021, in the list of Group A officers, the petitioner is at serial number 5 and the respondent is at serial number 4. 5.1. Against the seniority list, this is for the first time that the respondent was placed above me. Against the seniority list dated 21/1/2021, the petitioner submitted a representation dated 3/2/2021. The seniority list showed that the respondent number 3 is senior to her. She prayed for correction of the same. Then 5.2. The representation of the petitioner was considered by the NIDC. Subsequently, by order dated 17/2/2021, a corrected seniority list was issued. In this seniority list dated 31/3/2021, the petitioner is at serial number 4 and the respondent is at serial number 5. So all along, I have been treated senior. Only in one occasion, the NIDC tried to make him senior. I complained, it was corrected. Then, paragraph 6, in addition, that in the year 2023, the DPC was convened to consider promotion to various categories of posts in the NIDC. The incumbent managing director retired on 31/3/2023. By notification dated 3/5/23, the Government of Nagaland Department of Industries and Commerce allowed the Commissioner and Secretary of the said department to hold additional charge as the MD of the NIDC. When the proceedings of the DPC was held, the Commissioner and Secretary, Department of Industries and Commerce, was the chairman as well as the managing director of the NIDC. This position obtains till today. Now this has changed, of course. Then 6.1. Prior to the proposed proceedings of the DPC, an office circular dated 6/3/2023 was issued. This circular requested all DGMs in line for promotion to GM to be present on 10/3/2023 before the DPC convened in the office chamber of the Commissioner Secretary, Department of Industries and Commerce, Government of Nagaland, Kohima. The petitioner attended the proceedings of the DPC. She was summoned into the chamber and asked only 2 questions. What are the schemes under the NIDC for which loans are disbursed? 2, what is the dependency of cases in the NIDC? She answered the questions put to her. Her interview before the DPC hardly took a few minutes. Respondent number 3 entered into the office chamber and after the petitioner, and he also exited after a few minutes. Same type of questions, hardly a few minutes. Maybe Suku Biang Hasri Pula, I could read without. Gimana sih? Oh, different parts. Like, reading our phone. Okay, wait, that's right.